A few moments later.
But go fuck yourself. Is that clear? I hope it is. Hey, Bob.
Yo, what's up, everybody? It's your boy, Legal Mindset, Andrew Esquire here. This is Legal Mindset. We teach you to be your own judge. And we're coming to you with a second stream of today. Yeah, baby. Yeah. And it's a miracle. I'm both on time and my mic is working. So, miracles can happen sometimes. I like to say I only get one of the two. You either get my mic working or you get me on time. You don't get both. But today you got both. It's the miracle of Gina Carano. We're going to talk about some Disney topics today. Actually, I have 3 topics to get through. We're going to go Gina Carano. We're going to go to the arbitration, and then we have a little update on the theme park. Actually, let me post. Let me going live on the latest Gina Carano W as well as other Disney news. So yeah, I'll put this on X. I forgot to drop my X update. How dare I? How dare I? Should I post it on Blue Sky too? No. I'm not going to post it on Blue Sky. Sorry, Blue Sky. You don't get this update. This is only the Mouse House is only for Twitter, specifically doing it for you, Elon. Doing it for you, Elon Senpai. But I appreciate everybody here today. Ryan Bannon, 10 Canadian dollars for educating morons like myself. No problem. Ryan was asking about the Disney tapes, and real quick, I'll mention that while he brought it up for Super Chat. The Disney tapes were exposed by James O'Keefe about 3-4 months ago, where he exposed that they have extremely illegal practices regarding their hiring, promotion, etc. The relevant lawsuits that would really activate that information are still pending or still waiting to get authorized. So there's some that were more certifying a class and going after Disney at large. Those are still pending, but they could come up. The Disney tapes could come up in the Carano lawsuit during discovery. So we'll talk about that a little bit of like what can come out during discovery. And that's the relevance of the tapes. But the tapes themselves don't form the dropping of the tapes doesn't form a reason for people to, or a reason for them to be arrested, sued, yes, but not sent to jail on that alone. Although there's a lot of stuff in the House of Mouse that might end up getting some people thrown in jail. But hey, that's for other streams. Azriel said gold medal for no scuff and on time. Thank you so much for that 10. Appreciate that. Yeah, let me drop the JoJo. Yes. Thank you so much for that. Doug Diaz gave 5 Legal Mindset memberships. Once again, thank you. Let's go with
Hello, beso de pato, man.
Thank you very much. And if you got one of those, if you receive one of those memberships, please say thank you to Doug Diaz for that gift, because the kind gifters are the way that y'all end up having access to the awesome emojis like the castle emoji, which is always great to see. I see some people dropping some castles in the chat. Appreciate all that. Some rats as well. Good to see that in the chat as well. All right. So we're going to get right into it and jump right into it. By the way, real quick, I am going to be doing the Sarah Boone trial, but she is really crazy and she's dropping a bunch of pretrial motions. So what she did was she kind of delayed the start until tomorrow. So I'm setting it for tomorrow morning to kind of come in on that. Now, I did say I'm looking for some yappers. I'm looking for some other people, not lawyers, to talk with me. Now, some people have hit me up already. My preference and my bias is towards people that are already existing content creators. Now, you don't have to be big, but you do have to be a content creator just so I can look at your content, see your presentation style, etc. Make sure you've got a good microphone, right? You've got a good camera, whatever else, so check out your work, your channel. So it is biased towards that. If you're not a content creator, I'm sorry. There'll be other streams for you to come on. I'll have an audience, stream on another one where I just drop the link probably on locals and have anybody come join who wants to join. I do those streams from time to time. But for this one, if you're a small channel, even if you're small, you got, 50 followers, 100, that's fine. It doesn't have to be a huge content creator, just enough so I can see you're active, you're doing work, stuff like that. I can have you help me out by just coming on and yapping with me. So real quick, thank you, Mazrova Palma. And then on top of that, Muzzy Skeleton. Holy moly.
Not a sin. I cannot absolve you. Mega based.
You guys for dropping 40 legal mindset memberships. Thank you. Really helps me do this and inspires me to do this all night. And this is my second of the night. So it's taken a lot of power, but I'm happy to come back and talk about this. This is one of the cases I said I would follow. With Disney coverage, I don't want to just be covering stuff like shitting on Tiana's Bayou Adventure for the 100th time. I know it's fun to shit on Tiana's Bayou Adventure for the 100th time, but I try to stick to stuff where it's either a legal or really a business, a regulatory thing, maybe securities, maybe something with their filings, right? Stuff where my opinion is more valuable, right? Rather than just, oh yeah, this sucks. Because there's a lot of Disney stuff that sucks. That's why people are turning to anime. That's why people are turning east. That's why, as I've said, there's a rise in Eastern media and also a rise in VTubing. Because instead of people watching Disney shows, which they're clearly not, they're tuning in and they're watching other stuff. They're watching a hell of a lot of anime. JP Ravenfire gifted 5. Thank you so much. And then Orsif Platz gifted 20. Thank you, JP. Orsif Platz, Mazrova Palma, Muzzy Skeleton, Doug Diaz. Thank you all for this. Appreciate that so much. Yes. We're actually hitting this is like a speed record. We're almost at 100 and we're at 68 in the first 7 minutes. That's pretty quick. But thank you guys. Thank you. Mexican Iron Man said, my favorite part of this Gina story is that day one, you said how this will play out. And despite a bunch of YouTube commentators saying you're wrong, yet again, so far right, #Andrew's right. Yeah, a lot of other people were saying, oh, well, this is going to die. This is going to get dismissed on a motion to dismiss. Now they're literally going to go to discovery. She's already beat the motion to dismiss. She's now beat another procedural trick. She's defeated Disney twice. It's going to discovery 100%, right? And I always said the win for Gina is discovery, because then we get to see the dirty laundry of Disney and exactly how dirty the House of Mouse is. And it's going to be ugly for Bob Iger once they get inside his panty drawer. And that was always the W, but a lot of people doubted it. A lot of haters were out there. I ranked a lot of people's takes on this, and I may have given some people some Fs for their lack of knowledge of this. A lot of people were saying this was some sort of sexual, this was purely a sexual discrimination case or purely workplace harassment in a federal claim, and they ignored the California labor laws. They didn't even understand the specific California labor laws which prevent discrimination based on viewpoint or political preference, right? So they really analyzed this thing completely wrong. Gina came in this with a strong case to at least get to the point where she gets discovery, which is what she wanted, what Elon wanted. Because remember, this is an Elon Musk funded lawsuit, and Elon fucking hates Disney. I mean, he hates Disney. Let me play that intro clip one more time.
But go fuck yourself. Is that clear? I hope it is. Hey, Bob.
He fucking hates Bob Iger. And that's the Bob. In case you guys don't recognize him, some of you may be new to the channel. That's Bob Iger with the tears on the thumbnail, right? Because he is crying right now. By the way, you guys we're almost there. Holy shit. Azrael gifted 10 Legal Mindset memberships. Clemson Splat gave 5, and Doug Diaz another 1. So we got 16 there on top of that, 14 away from 100 within 10 minutes. Holy shit. That's crazy. That's crazy. I love it. I'm looking at this and I'm just like,
What the fuck?
I appreciate you guys and your support for me. Appreciate that. And guys, if you're receiving one of these Legal Mindset memberships, the gift memberships from anybody, Crimson Splat, Ezreal, Doug Diaz, Mazrova, Muzzy, Anybody who's dropped one, please say thank you in the chat, and please give your appreciation for that. Fallen Hero has also been a member for 8 months. Welcome, welcome. Neil said, keep up the good work. Hopefully Gina can win the case. I hope so too. And frankly, she deserves it. She's a very wonderful woman. She did not deserve what was done to her. She's not that political. Gina Carano is not Ann Coulter. She's not some person who is, out there being political every single day, making radical political statements, etc. Right? She's not that type of person. She's just an actress who doesn't agree with fucking crazy activists. That was it. She just purely did not agree with her super ultra activist compatriots, right? The folks that are fellow actors, and that was her sin. Her sin was that she didn't fall in line. It's not her. Once again, people should be allowed to think freely, whether that's right, left, neutral, or just not giving a fuck. You should be allowed to do that as well, right? And not have to virtue signal at every turn. And just because she doubted the COOF, right, which proved to be valid the entire time, right? Spoiler alert, she was right. She was right about everything she tweeted about. She was right, and her coworkers were wrong, ultimately. She's suddenly exiled for being right and just expressing a opposition to a policy, right? An opposition to a policy. Yeah, many people were wrong. And by the way, but I know in my chat, you guys are following me, especially if you've been following me for a while. I always said that what was going on during the pandemic was illegal. It was unconstitutional. The Supreme Court validated that. We were all right on that. We were right here in chat. But most people, a lot of people were wrong. Were dead wrong as to what was legal in the U.S. It was insane. Jim Watari said, go, Gina, go! Agree. Lauren S. for 99 said, go, Gina! Agree. Oliver Closeoff said, hashtag free Aspen, hashtag lock up Disney, and go East gentlemen. Also, special thanks to our friends at Law and Crime Network for their help and support the channel. Motherfucker. Law and Crime, I wonder if I'm going to use Court TV or Law and Crime tomorrow. We'll see. If I want to play dangerously, I'll use Law and Crime. If I want to live like safely, I'll go with Court TV. They're cool. Court TV is cool. I wonder if Chanley is going to be there. Our spicy green dressed reporter. I think she may have moved. Did she move? Did Chanley move? Chanley may have moved. I'm not sure. Triple J26 says, let's be real. We all don't like Bob Iger. I do hope Gina Carano comes out on top once it's all over. Exactly. Nobody likes Bob. I don't even think Bob Iger likes Bob Iger. I think Bob Iger looks at himself and is like, how the fuck did I get in this position? He was supposed to be running for president. He should have been running for president this election cycle. Instead, he's overseeing a dying carcass where all of its elements, which once were winning big, are now failing. He probably regrets his life right now. I'm just saying. All right. Chanley is on Fox News now. No, Chanley. Oh, no. Thank you for letting me know, Joe Schmo, on Locals. Appreciate you and all the Locals degenerates. You guys make it fun. All right. So let's start with the Gina complaint. Now, we're going to go through this procedurally and kind of read through this. It is not too long. It's 10 pages. So we're just going to read through the whole thing because I like to give you guys the original. I like to give it to you raw. This is fresh off the presses. This was literally recorded at the court on 10/15. It just went public. It takes a couple days for them to upload these things and get out there. So appreciate this kind of going out. It is the United States District United States District Court, Central District of California, Gina Carano plaintiff versus Walt Disney Company, Lucasfilm, and Huckleberry Industries. This is the sub company that was over the Matrix. The Mandalorian, because this is all related to her casting on the Mandalorian. How did I say the Matrix? Oh my God. And this is case number 224 CV 101009 SPG SK. You can look up the case. It's in California. It's in federal court, but this is the district court. So this is, if you imagine courts, there's three levels. There's state courts, which have the basic court, right? The lowest level of court, whatever that level is in the state, they call it different stuff. Usually it's district court, but it can be called something else. You have the district court, the appellate court, and the Supreme Court, both at the state level and at the federal level. So this is at the district court level. Now, this is a motion, this is actually an order denying a motion for interlocutory appeal. So what they wanted to do was they wanted to get this sent up to the appellate court. They wanted to raise it one level to answer a legal issue, because in certain extreme circumstances, very extreme and extraordinary, you can go up to the appellate level to answer certain legal issues. However, it's extraordinarily rare, it's hardly ever granted, and it's hardly ever appropriate, right? Now, once the whole case has been decided, they can appeal. But here's where Disney needed to rely on this. They needed to rely on this because they don't want discovery. This is what I said from the beginning. Disney doesn't want their emails getting out there because they can get some serious corporate damage if their emails get out there and they say, yeah, we actively discriminate against white people. Yeah, we actively discriminate against people who are espousing Republican views, people that are not espousing the party line, that people that are going against what Joe Biden said or what the government narrative is, right? That will really hurt them as a company. Publicly, it will shame them. They've been hiding this fact. They've been denying this fact. The fact that that would get out there would absolutely wreck them as a company. They would take a massive hit, right? It would be really, really bad for them, right? They might even face a shareholder lawsuit over it. I mean, there's a lot of stuff going on with that, right? Because they made statements that they don't do that they don't engage in that behavior, whereas we know that they actually do engage in that behavior. It's been very clear. So that's why it's interlocutory, right? They're now it's denying. So that tells you how this came out. We have a spoiler on how this came out. It was denied, meaning we have in the opening, we know that Gina won and Disney lost. And now one thing I will say is, and this is a very good thing to point out, I have always told you guys, Disney's number one superpower is not smart lawyers. It's lawyers that can tie you up in procedure. It's lawyers that will tie you up in court for years and you're going to run out of money. That's exactly what Disney's power is. And this is exactly what this was trying. Speaking of tying up, though, Ezra with another 5 and then Sinner for another 10, getting us to 101. We did it, boys. We did it. Yes. Thank you so much for getting over to 101 Dalmatians. 101 based legal mindset memberships. Appreciate that, guys. Coming in hard today. You guys deserve it. You really do. I mean, there's no way to say thank you other than the fact that I appreciate you guys. You guys are the best. And I'm glad we can have fun here. We can talk shit and we can go over legal cases. This is exactly what I love to do. And thank you for allowing me to do that. Speaking of talking shit, Comic Art Pro Secrets says, where's Ricada? Did LawTube have him whacked? Well, is this Ethan? Is this Ethan? Is this EVS? Or is this like an EVS copy account here? Anyways, Nick has not been streaming for over a month, but he was one of the ones that said this was not going to go to trial. This was going to get motion dismissed out. Gina was going to lose. He faked concern about this, saying, I'm so worried about it. Even though it was complete bullshit, he was just doing it to have a contrarian opinion because I said one thing and he was mad at me being beta rage, so he said another. It was just one of the many bad opinions and bad takes on this, right? So yeah, he's currently probably in the Baldo bunker, hunkered down, waiting for his trial. From what I've heard, and we'll probably have some Ricada legal updates, I imagine, a month or two. He's planning to take his case to trial, which is a whole fucking mess, and that'll be great if that's televised. I mean, we'll definitely be doing the full trial of Nicholas Robert Ricada, if he decides to go to trial. So cool beans. Listen, whatever it is, EVS, I'll tell you, it wasn't Eric July. Eric July didn't do it. Okay, if it's EVS, Eric July did not do it, brother. He didn't do it this time, right? He can't keep getting away with it. Major Rule says Gina's case is a stone that starts an avalanche. Yeah, it's going to open so many doors. And they're trying to slow roll it. They've already slow rolled this. They've slow rolled this for a while. And they're going to continue to try to do what they can, but this was a really last move procedurally before discovery. The only thing they can do now is claim that certain items are exempt or privileged. So what they'll do is they'll claim things are exempt or privileged. That's what they'll try to do. But that's weak as fuck, right? All right, let's try it here. Before the court is defendants Walt Disney Company, Lucasfilm, Huckleberry Industry. Huckleberry. I mean, when you bring in Huckleberry, it's going to, no, it doesn't sound good. And their motion to certify for interlocutory appeal and stay of proceedings. The court has read and considered the motion and concluded that it is suitable for decision without oral argument. Bro, Disney got beat so bad. This is how bad it was. Disney got beat so bad, they didn't even allow them to speak. Understand this. Usually, they will allow counsel the time to submit a brief, and which is a written statement of the law, a written argument, and also an oral argument. This was so bad, they didn't even give them oral argument. That's a shitty argument. That's a really shitty argument, which means they were just doing this for delay. They probably knew, even the lawyers probably knew this wasn't going to work. It's sad. It's so sad. Having considered the party submissions, relevant law on the record, the court denies the motion. Plaintiff Gina Carano filed this lawsuit asserting various wrongful discharge and sex discrimination claims after defendants terminated her from the Disney Plus show The Mandalorian. Defendants moved to dismiss the complaint, contending the First Amendment barred her claims. Remember, my First Amendment! Disney always cries, but my First Amendment, I'm a giant corporation. Oh, stop picking on me. I'm a giant corporation. Oh, boy. Oh, who's going to defend the rights of this giant billion-dollar corporation? Oh. They lost on that. After considering both parties' briefing and oral arguments, the court issued an order denying their motion to dismiss, so defeating Disney's motion to dismiss, which was their best chance at winning. Defendants answered the complaint and filed an instant motion requesting they certify an order for interlocutory appeal and stay of the proceedings. The plaintiff timely opposed and defendants timely replied. So they oppose it and they reply. Disney's lawyers are getting paid so much fucking money for all this unnecessarily filings they throw out. It's ridiculous, right? As a general rule, the parties may not appeal a district court's rulings until after the court enters a final judgment. That is a general rule. So interlocutory appeals are special. They're only if, as they say here, pursuant to 28-1292B, they're only able to appeal if conditions specified in the section are met. And the district court certifies and the Court of Appeals exercises its discretion to take up review. Specifically, it needs to be one of these things to get an interlocutory appeal, to go up to the next level before they finish the case. Involve a controlling question of law as to which there's substantial ground for difference of opinion, and an immediate appeal may materially advance the ultimate termination of the litigation. Even if the three are satisfied, a district court still has the discretion in deciding whether or not to grant it. So even if all those things are true, they still could turn them down. And it has to be a legal issue, not a factual issue. Because the thing is, appellate courts don't answer factual issues. They answer legal issues. And at this point, by the way, we have barely any facts because we haven't gone to discovery. A district court should only grant it in exceptional circumstances, in which allowing an interlocutory appeal would avoid protracted and expensive litigation. The party seeking certification has the burden. So Disney had the burden of proving this. An interlocutory appeal should not function to merely provide review of difficult rulings and hard cases. So it's more than just, oh, this is hard, or oh, this is a big case. It has to be a real, contentious, difficult question of law. Whether a First Amendment right of free speech protects an artistic entity's right to control its own casting decisions by declining to express its art through actors who made widely publicized statements that the entity deems offensive and harmful to its own artistic expression. This is complete bullshit. They tried to say that there's some big pending question of law about First Amendment rights of an artistic entity. First of all, they're not an artistic entity. They're a fucking business. They're a fucking business. To control its casting decisions. You mean fire and hire people? That's what the case is about, whether you wrongly fired her or not, right? So you're trying to reframe to control its casting decisions. You're reframing it to fire somebody based on their political belief by declining to express its art. Oh, we're just artists. We're just expressive artists. Through actors who make widely publicized statements, Gina Carano, that it deems offensive, saying that COVID is going off the rails and expressing some opposition to that through memes. Through fucking memes. It's insane. Real quick, Tatsumi says, happy buying front row tickets and popcorn to watch Disney's downfall. Indeed, we're watching it right now live. Big Leo says, I'm still happy when Warner Brothers and DC Warner Brothers cost DC and Marvel their trademark on the word superheroes. Oh, that's great. That's great. Sigrun Eterna says, to be fair, I think before Elon started funding Gina, I think it was fair to say it wouldn't have gotten very far because Disney would just stall. Yes, it was fair to say Disney would stall. And if Elon had not funded Gina, she wasn't going to go forward with it. Gina's been interviewed and Gina said, I wouldn't have done this without Elon. Gina said, thank you, Elon, because Elon's the one that made this possible, right? This really wouldn't have been a case without Elon. I agree. She wouldn't have the money, but Elon's like, nope, fuck it. I got money for this. Fuck you, Disney. And that's what you need. You need powerful people who are backing you monetarily to win in lawfare. And that's how lawfare works, like my mod Danielle says. Anthony says, to be fair to Rakeda, Gina probably wouldn't have been able to bring it to trial if she didn't have Musk money back in her. But that wasn't what Nick said. If Nick said that, I would have given him like a D or a C or something like that for like just bringing up monetary stuff but not legal stuff. But no, he actually thought this was some sort of other case. He thought it was a defamation case. He was. I mean, we now know he was high at that time, right? Admittedly, confessedly, he was drunk and high when he was making that statement on cocaine, right? When he made that statement that it was a defamation case. So it explains his take. It explains his take completely. Like he was doing the Colombian booger sugar, right? But he didn't bring up that practical element. That wasn't what he brought up. He brought up that it's defamation. And he brought up New York Times versus Sullivan, which is not even relevant. It's crazy. Oliver Klozoff says, say you were in Gina's shoes. How much money would you take to settle? Pepperidge Farms remembers when Andrew fought Disney in special district court. Yeah. Gina said it's a tough thing for her. She would think about it. But I mean, I think, look, if they offered her something like, I don't know, 50 million, 100 million, it would be hard to turn down. Right? It'd be really fucking hard to turn down. Now, Elon could turn around and say, hey, listen, Gina, don't take the money yet. I got you, girl. And we want the discovery. And I think Gina wants the discovery. I think Gina, to me, comes off as a woman of principle. And she comes off as a person who wants to prove that she was morally wronged. So I believe that Elon and Gina combined want to set the record straight. Like Johnny Depp. Johnny Depp didn't want the money. Johnny Depp wanted to clear his name. Gina wants to clear her name. And I think that's where they just say, hey, go fuck yourself. We're going to discovery. Sorry. And the point at which they're going to make the settlement offer is going to be soon. Real soon now. Because now they've exhausted their legal excuses. Azrael for €5 says, the system truly is broken when you can hardly win without lawfare. It involves tons of money. Yeah. And it is unfair. That's why oftentimes, guys, you see me when I cover stuff saying lawsuits aren't the answer, because the corporation that has a shit ton of money is going to use a ton of leverage there to pummel the other party, especially when it comes to corporations versus individuals. It's not a fair fight. It's not a fair fight. And trying to pretend it is bullshit. And other lawyers were like, yeah, it's the little guy. Court's about the little guy. It's not about the little guy. It's not about the little guy at all. Disney is proof that paying lawyers that can procedurally delay is a strategy that will typically win. This is an exception where they lose, but they do typically win. Now, there's another case we're going to cover today where they lose, but we'll get to that later. Sorry. Let's continue. Although it was not entirely clear from their motion, this is actually a jab. The judge is actually shitting on their lawyers. They're saying they didn't write it clear enough. That's crazy. That is nuts. STS IN2, welcome as a new member. Defendants may also seek certification. They're saying, oh, well, it wasn't clear, but we also considered these other questions because they brought up all these other questions. They should have said it clear. By the way, yes, as Mexican Iron Man says, smash a like and share the stream. Thank you. Whether a court must defer at the pleading stage to an expressive entity's concern that associating its art with speech it deems offensive would impair its own expression. Whether an artistic entity has the right to consider an actor's off-the-job political speech when making casting decisions. Whether the First Amendment prohibits the use of state power to control private speech through equitable relief, but allows the use of state power to control private speech through monetary liability. And whether the First Amendment protections identified in cases like Green are applied differently in an employment context. Okay, so those were additional ones that the court gave them as a freebie. So they only needed to give them this one, but they considered all of this and they still said no. W is in brackets. W is in brackets after each because it was capitalized. So like a capitalization or a pluralization, you put brackets because it's not a quote, it's a semi-quote, right? So the court added the W and then they cite it, right? Okay. They added the capital W. It's probably lowercase w. Still a W, right? All right. Whether the defendant identifies a controlling issue of law. So the first question is this a issue of law that needs to be resolved by a higher court? A controlling question of law must be one of law, not fact, and its resolution must materially affect the outcome of litigation. A pure legal question is one whose answer is independent from the facts. So the law is something that is true regardless of whatever the facts are. Regardless. Period. End of story. It is the law. I am the law. Right? It's the judge dread. A party presents a controlling legal question when it alleges that a court articulated an incorrect legal standard. In contrast, where the question posed for appellate review would necessitate a detailed inquiry into the record, meaning if you need to look at any facts, it is likely a question of fact or a mixed question of fact and law. And we do not, we do not mix fact and law. We do not deal with the intermingling of fact and law. We keep them separate. Now, they're not equal. Law is more important than fact. There's a little bit of a two-tier system here, but we do not mix fact and law when it comes to interlocutory reviews. The question must be a pure question of law, that can be resolved quickly and without having to study the record. Routine applications of settled legal standards. The facts alleged in the complaint are not proper for interlocutory review. Here, defendants contend, by virtue of having ruled on a motion to dismiss, the order necessarily raises a question of law. So they're saying because we lost our motion to dismiss, it's automatically a question of law. That doesn't even fucking make sense. That doesn't even make sense, to be honest. In opposition, plaintiffs argue that defendants, in fact, seek review of a question of fact, but not one of law. The court agrees here that defendants have failed to present a pure question of law suitable for review. So boom, they lose. What they're asking them to do, all these things, when they ask them these questions about the statements, about their artistic expression, you need to look at the fucking statement to determine whether or not this is even an issue You need to look at the underlying statements. You need to look at the facts. We don't have those yet. We don't. So, as an initial matter, the invocation of Placid is misplaced. Placid arose on direct appeal. It was dismissed for lack of jurisdiction. So they're citing other cases. Defendants contend that ruling on a motion to dismiss necessarily concerns a controlling question of law. In fact, defendants' motion makes it clear the real issue is with how the court applied various precedents to the case in hand. In effect, defendants seek an opportunity to have the Ninth Circuit review whether the court concluded the defendant's affirmative defense was not impenetrable, as required to prevail on a motion to dismiss under Ninth Circuit law. So they're trying to get a second bite of the apple. Why are they trying to do that? They're trying to do that because the Ninth Circuit Court of Appeal is one of the most woke, biased, skewing far left courts out there in existence. The Federal Ninth Circuit Court of Appeals. They wanted to go to the wokest of the woke, the leftist of the left, the most biased circuit ever in existence in all of these United States, and try to get a favorable ruling from people that they thought would be in their court, because in this case, they're representing the left. And Gina represents the evil far right, even though, once again, Gina is never identified as even a Republican. She's not even really necessarily political. She had an individual opinion on an individual issue that didn't align with the woke narrative that Disney needed to be pushed forward, right? They were pushing for a specific narrative, particularly regarding the pandemic, right? And so they needed to go to that Ninth Circuit in order to get that favorable opinion. By the way, Walking Corpse gifted 5 Legal Mindset memberships. Yes. Thank you so much. Appreciate that, Walking Corpse. Appreciate it. We're now at 106. Actually, 107 new members today, because it's counting not just new memberships, gift memberships, but new members. So thank you very much. Also, that dog in them says, for 10, says, settlement coming soon. Disney absolutely doesn't want discovery. Unless the activists prevail, then the funds and funny begins. Everyone but the mouse will be making bank. Yeah, I'll make bank. Once again, I want Disney to go to trial on this. I would love to cover this, right? I love it when people take stuff to trial. Like they just make it news. They just make it stuff that we can cover, we can go over and analyze. It's great. Take it to court. Please take it to court. Please keep fighting back. Don't settle. You don't want to settle. Settlements are boring. Let's do trial. Trial's way more fun. Anthony says, if I was Gina right now, I would tell Disney I will settle for $175 billion, aka the net worth of Disney. Yeah, they're not going to do that. They can't do that. But that would be funny, though. How much would you settle for? Your net worth. Fuck you, Iger. That'd be great. Cajun Bowser says, it's called the Ninth Circuit for a reason. That's true. Ninth Circus for a reason. I was just imagining when you said Cajun Bowser, I just imagine like a giant pot of gumbo and like Bowser like putting the Cajun seasoning in the fucking giant thing of gumbo. It just fits for some reason. It just fits. Tatsumi says, is there a motion that can be filed to inhibit the ability of a party to engage in lawfare? No, that's the problem. It's the problem. They get to use all these procedural attempts. They get to make every motion they can possibly make, everything they can possibly afford. Which is almost everything. They can do that because that's their right. That's their due process right to make every motion, even futile motions. They've got to pay their lawyers for them. Andrew, you'd be correct, sir. Yeah, no, it's a good image, right? It's a good image. Magma Fox said, I sometimes forget that I've been here a while. Also, Castle. What's up, Magma Fox? Good to see you, brother. 7 months, man. Awesome. Let's continue. Whether defendant establishes substantial. Also, there's 1,500 of you. If you could smash the like button, your boy would appreciate that. Thank you very much. Thank you. Whether defendant establishes substantial growth for difference of opinion. Substantial ground, for difference of opinion. Even if defendants have raised a controlling question or questions of law, however, they have failed to meet their burden to show substantial ground for difference of opinion. Courts generally find that a substantial ground for difference of opinion exists where the courts are in dispute on the question and the Court of Appeals of the circuit has not spoken on the point. If complicated questions arise under foreign law, or if novel and difficult questions of first impression are presented, in contrast, that settled law might be applied differently does not establish substantial ground for difference of opinion. So saying that law could be applied differently by a different judge is not enough. Say that, oh, well, a different judge would have ruled a different way. That's not enough. That's not good enough. Sorry. Not good enough. Similarly, a substantial ground for difference of opinion is not established by a party's strong disagreement with the court ruling. So, and this is what they had here. Disney was just butthurt that they didn't get a ruling in their favor. That's not enough. Here, defendants have not identified a circuit split on the proposed questions. That means they haven't found courts that have ruled differently. That's what a circuit split means. A circuit split means that there's differences of opinion with different courts. That hasn't been identified on these questions. These are novel questions. Instead, defendants argue that reasonable jurists could disagree about how these precedents apply to the case at hand. That literally is not the standard. And I think the lawyers knew that when they filed this. I'm confident they knew that when they filed this. But under Ninth Circuit law, this argument is a paradigmatic example of a failure to establish a substantial ground for difference of opinion. Additionally, although defendants purport that to identify 4 critical aspects of the order's legal analysis, which reasonable jurists could allegedly disagree, this portion of the motion fails to accurately characterize the reasoning of either the order or the defendant's case law, let alone show substantial ground for difference of opinion. Bro, it means they aren't even accurately describing the real arguments. They're ignoring. Disney is not even making the right arguments. It's crazy. First, citing Green, defendants argue that reasonable jurists can conclude that the standard applies, or the deference standard applies to the entirety of the lawsuit, including the pleading stage. Defendants contend that this began as a motion to dismiss and was converted to summary judgment only on a limited issue of no relevance here. Defendants also assert the Ninth Circuit's ruling in Green was not based on a developed summary judgment record of undisputed facts. Defendants are wrong. So literally straight up saying, Disney is wrong. In Green, the district court converted the motion to dismiss into a motion of summary judgment so the parties could engage in limited discovery and submit supplemental briefing on a question of whether Miss USA is an expressive association and to evaluate the pageant's freedom of speech claim. The limited issue on which Green was converted to summary judgment was on the question of whether the defendant was an expressive association. Far from being of no relevance to the order, this question is essentially relevant. So saying in that case, it's much different than here. It's entirely different than here. In contrast, the order was not decided in such a posture, meaning this is a different case. Second, defendants contend the order held that the First Amendment does not confer on expressive entities the right to disclose with performers, right to disassociate with performers based on their off-the-job political speech. So the point is, Disney's trying to say, we want to be able to fire people based on what they say off the job, based on their political speech, which is at the core of the labor law. The labor law literally says you cannot do this. The labor law literally says California business entities cannot fire people for politics. And the reason why they did that was to prevent the evil conservative corporations from firing left-wing employees. But guess what? Here's how it backfired. Most major corporations are now left. And I imagine this law may be repealed because they're going to realize that in California, say, oh, wait, shit, this is working against our political side. So we're going to get rid of this law. Now, that won't change this lawsuit, right? Even if California scrambled. But I guarantee you they may change that law because they realize, oh, wait, all the big corporations are now actually really, really left aligned, especially California corporations. Any corporation that's still in California headquartered in a major corporation is extraordinarily left aligned. It's the way it is. By the way, S66 Seeker, thank you so much. Gifted 5 legal mindset. Yes. Steve C, member for 16 months. What's up, Steve? Says my White Sox have a better win rate than Disney law. Disney has every case I've covered from Disney has been a massive fucking Disney loss. Everyone. Andrew J. Natalo says 2 streams, 1 day. Yes, I'll have to catch up since I missed the start, but there's nothing like listening to Mindset while I'm working on litigation plans for insurance companies. Awesome. Thank you so much. I'm glad you enjoy the content. Thank you so much. If you could like the video, that would also be great, guys. But thank you so much for Super Chat. Andrew, it's a great name. Strong name. Strong name, Andrew. Thank you. Thank you for that. Gazalrian says, kind of sounds like lawyers, maybe DEI hires. Well, they are all from, like, their lawyers are from Washington, D.C., and California. So I'll leave that up there for you. Alpha O says, could there be precedent for the future if repealed? Well, what California would do is they would go to the legislature, they'd repeal it. So that would stop similar types of labor claims in California. But what we might see is other states, maybe even states like Texas, where a lot of big corporations have moved, passing laws like this, saying you can't fire people for political beliefs, and saying, hey, no, well, actually, we're going to do that because we want to protect our workers from the woke corporations. They're going to get with it. I can see that. By the way, Gundam Exia, very based. I'm listening to Legal Mindset while playing FF14. Awesome. All right. Let's see here. Indeed, the court explicitly recognized that defendants Disney might, with a more developed factual record, be able to prevail. And this is what I always said. Disney might be able to win. I never said that Disney wouldn't win at trial. They might win at trial, guys. They could win at trial. The win for Gina is going to discovery, and Elon is going to discovery and getting the emails and dirty laundry. That's their win, even if they don't ultimately win a trial. That's the W. That's the goalpost. Once we kick it through that goalpost, it's done. It's over, right? The W is there. That's something that we haven't seen, period. But speaking of which, Triple J 26 with 20 legal mindset memberships. Whoa, boy. Yes. Thank you so much. Appreciate that, Triple J. Very awesome of you. Thank you so much. And guys, please say thank you to Triple J 26 if you receive one of those memberships and for being so generous, as well as all our other very, very based gifters. Thank you guys for being members of the only BLM that matters. All right. Speaking of which, we were almost going to cover that shooting issue with the former basketball player, the Georgetown basketball player who was shot, but that one is just such a straightforward case. It's not even worth covering. Right. And that was one. It was very funny how BLM started to talk up about that one and then realized from like, oh, we're going to do a George Floyd part 2. And then when they realized they saw the video and the video is crazy. I can't even show the video. It's pretty crazy. The Concord edit was really funny. I agree with that. But the video is insane. And the fact the officer could have shot that woman immediately and he did not. He actually tried to de-escalate and was backed into a corner, right? And was forced to shoot. And he almost took a fatal wound to the head, right? It's insane. It's nuts. But anyways, I also saw the Doom edit as well. The Doom edit was also good. Insane, though. Insane. All right. Look at this. Look at this language here. The court will not certify for appeal a straw man argument conjured up by defendants in an apparent attempt to create conflict between the order and the case law considered therein. They literally called Disney's argument a fucking straw man argument. These guys are getting bent over legally. Yeah. And to clarify, in case I know there's some people that are confused about BLM. Yes, the stupid one is based on race. The based one is Andrew's membership tier. Both. are BLMs, but only mine is the base legal mindset. Thank you, professional gentlemen. Clearing that up for those that are new to the chat. Thank you, PG. A professional gentleman. Also, shout out to my mods. We have all three in the house today. Danielle, we have professional gentlemen, and I saw Don. He's there earlier. There's Don. Thank you, Don. We got a lot of them, and we actually got Mexican Iron Man too. So we got 4 mods in the house. That's very rare. That's a mod party. It's a mod party. Yeah, it's the good BLM. Jamie for 199 says no money. Ona ask for Favreau in Chat GPT and apologize. Thank you. Chaos and Control said for 199 the damage body cams have done to BLM is immense. Yeah, seeing the truth is crazy. Mexican Iron Man said BLMM is base legal Mexican mindset. I love it. Tacos for all. Courtesy of Mexican Iron Man. He's putting him in the kitchen because he has to mow the lawn, cook in the kitchen, and take care of about 12 YouTube channels, in addition to being a YouTuber himself. Hardest working guy out there, Mexican Iron Man. Shout out to Mike. All right. Similarly, defendants mischaracterize a 3-sentence. They can't even get 3 sentences right. This judge is cooking Disney, is roasting Disney. Third and similar, they mischaracterize a 3-sentence passage in which the court reasoned that the First Amendment may place certain restrictions on the remedy plaintiff may seek for her claims. Defendants, Disney, contends this material suggests that the First Amendment protections against state interference with casting decisions depend on the remedy sought. So they're kind of saying, hey, the First Amendment protects us from the court. Oh, the court can't do anything because the First Amendment. Again, as stated by plaintiff, meaning Gina, Disney misses the point. The court did not, as Disney insinuated, reach the issue of what kind of liability would be imposed upon Disney if Gina were to prevail on some or all of her claims. Given the contours of Disney's motion to dismiss, such a determination would have been premature, and accordingly, the court did not make it. Because this conclusion is not contained within the order, the court will not certify the order for review. Owned. Finally, defendants argue, and by the way, guys, so we're going through this, right? So the court is denying them. They only had to deny them once for this not to go. The court is giving a multitude of reasons why Disney fails. This is an absolute whomp on the head, right? It is an absolute slap to their counsel, to their arguments, and it shows that they're just engaging in what is lawfare. Finally, they argue that reasonable judges could disagree with the order's effort to distinguish leading cases on the grounds they did not arise in the employment context. Again, Disney misunderstands the order. In their motion to dismiss briefing, Disney asserted 2 Supreme Court cases. And the court's correct observation that neither of the cases that Disney cited were employment cases. So Disney, like many of the other lawyers, Nick, were citing cases that weren't even employment, right? They're citing random other cases that had nothing to do with this, which imply that these cases arose from the employment context. Additionally, nowhere did the order articulate any premise that the First Amendment protections for expressive entities apply with less force, if at all, in the context of an employment lawsuit. Tellingly, defendants do not offer a citation to any portion of the order in support of this claim, nor could they because no such material exists. Holy fuck. They're literally saying that there's no proof they could have offered because it doesn't fucking exist and they're making it up. That Disney was completely making it up. In sum, defendants failed to show a substantial ground for difference of opinion. Additionally, the court will not certify for interlocutory appeal holdings not made in the order, right? Okay, going down here, whether an immediate appeal will materially advance termination of litigation. Finally, defendants failed to establish that the questions which they seek to certify would materially advance the ultimate termination of litigation. Defendants argue if the Ninth Circuit reverses, then the case is resolved. As the court previously explained in the order, however, defendants' narrow focus on the question of termination overlooks Gina's allegations concerning various conduct they engaged in before and after terminating Gina from The Mandalorian. Because this conduct lacks any obvious artistic or expressive quality, Disney's affirmative defense cannot be impenetrable. You know, that's actually funny. You know how, I covered Niji Sanji. Niji Sanji's word was negligible. Disney's word is impenetrable. Our defense is impenetrable. Sir, your defense is made of paper mache. Their defense was as impenetrable as a 20-cent hooker. Plaintiff's lawsuit would move forward with discovery, regardless of how the Ninth Circuit might decide the certified question. Look at this. So this is important. Gina would get discovery regardless. And this is what they're afraid of. The judge is pointing out that the exact thing that they're afraid of, she's going to get. Oh, she's going to get it, baby. We're getting that W. Consequently, the court's decision to deny the request to certify for interlocutory appeal is not only consistent with 1292, but also well-recognized obligation of the judicial branch to avoid deciding constitutional issues needlessly. In short, the salutary principle that the essential facts should be determined before passing upon grave constitutional questions is applicable here. Although defendants invoke Green for the proposition that it is important to resolve First Amendment cases at the earliest possible juncture, the Ninth Circuit concluded that, in light of discovery, the trial ordered on expressive association, the court had a record sufficient to resolve the case on defendant's free speech claim. In contrast, in this case, the order makes abundantly clear that given the allegations, the court lacks the record sufficient to resolve the claim based on Disney's defense. We need discovery. Disney wants us to decide this with no proof. But guess what? We need proof. And Disney knows they're fucked if they have to give that proof. Disney also asserts that if the Ninth Circuit affirmed the order, it would protect Disney's constitutional interest in avoiding costly speech-chilling discovery proceedings. Defendants do not, however, explain how a Ninth Circuit opinion would alleviate the burden of responding to the discovery plaintiff has propounded to date. Nor is it apparent to the court how such a decision could provide such relief. And I'm still getting over a cold here, guys, so bear with me. I'm sorry about that, guys. I'll only apologize to you, nobody else. I'm not Asmongold. In any event, arguments regarding discovery, which the court notes were not an issue in the order, do not appear to have any bearing on the termination of litigation and do not persuade the court that certification is appropriate. Conclusion, for the foregoing reasons, the court denies defendant's motion. It is so ordered. October 15th, Honorable Sherry Lynn Peace Garnett, based. Sherry, baby. Don't fuck with Sherry. Sherry just fucked you up, Disney. That was a killing. Guys, I've read a lot of motions. That's a slaughter. That is a slaughter. Disney got absolutely destroyed. And it's nuts because now we know we're going to get discovery. We know. The court said it. They're like, nothing's going to stop discovery here. So we're at a point where Disney needs to say, Gina, how much money do you want? We'll give it to you in bags. We'll give it to you in, gold bars. I don't think Gina would take stock because that's going to be plummeting. Masrova Palma says the judge looks very annoyed with Disney. You know why? Here's why. Judges know when you're doing procedural fuckery. They know. They're not stupid. This is a federal judge. They're typically at least smart, right? They may be biased, but they're typically smart. And they know when they're engaging in procedural fuckery. And yeah, you're entitled to do it. But you know what it does? It pisses off the judge. Because you know what they're doing here? Their motion is saying, Judge, we're smarter than you. And we want to go over your head. And there's nothing a judge hates more than saying, you think better than me and you want to go around me. Judges don't like that. They don't like to lose on appeal. They don't like their cases to be appealed. They don't like their case to be overturned. And they don't like people questioning their legal judgment, because this type of motion questioned their legal judgment. So it's saying this judge had deficient legal judgment. It's a waste of time and a waste of resources. What's up, Midnight's Edge? Good to see you, Tom. Or Andre, whoever it is. I think it's Tom, probably, but good to see you. Good to see you, Midnight's Edge. Ezreal said, good. Happy to see good BLM grow so much. Yeah, it's awesome. We've had in this one, in this stream, let me look at 133 new members, provision of new grief being the latest one. Thank you. Welcome to the membership. Appreciate that. Lenmar said, hey, Andrew, any chance you'll cover Nintendo versus Ryan Daly, the Switch modder representing himself just for the lulz? I'll look into it. Lenmar, do you want to email me that, brother? Or send it to me? You got my Twitter as well. You can DM me or email me, but send me over the info. I'll take a look at it. Yeah, sure. Mazrova Palma says, let's look at the judge. Yo, got that one. Yeah, but the judge was annoyed, Mazrova, for sure. For sure. Oliver Klozoff said, Star Wars Discovery greater than Star Trek, bro. Star Wars has always been greater than Star Trek. I mean, until now, when I don't count new stuff, I just count OG, right? Old school. Disney Defense is like the Maginot Line. Yeah, and they just got Belgiumed real hard. Tim asked for 20, said Disney, how much do you want? Do you want it in bags? Gina said 75% stock and board seats, including Bob's. That would be great. Controlling stock. Smoke Jaguar said, this is why I follow the channel. Good stuff. Yeah, this is good stuff. I mean, once again, guys, I'm going to stay on top of the Gina case. I promised you specifically the Gina case. I will stay on top of this. But we're a big shout out to Mexican Iron Man. He supports so many channels. I know Tom's out there. He helps Tom out. He helps me out. Thanks for bringing this to my attention. Help me dual stream tonight. There's certain things I'll do. I cover a variety of topics. I have a lot of requests for topics. You see people send them in. I have emails. I've got somebody who wants me to cover unauthorized use of force. I've got people who want me to cover all sorts of other technical lawsuits, etc. The NASCAR lawsuit, all sorts of things. So I do try to focus, but Disney has been one thing that I focused on. I still focus on when it's a major lawsuit, right? Not just a small thing. But there's another big one we're going to get to today with their infinite arbitration lawsuit. So let's get to that one real quick. So some of you may remember this one and some of you may not, but Disney lost another lawsuit. Oh, it's not just this one. They had a big tactical loss. So they had filed this motion. And now this is a Florida case. And of course, I'm a Florida lawyer. In the Ninth Judicial Circuit, this is the same one that Sarah Boone trial will be during, the Ninth Circuit. And this was Jeffrey J. Piccolo as the personal representative of the estate of Kankaporn Tungswan. She's actually Thai doctor, right? Who's the one who died. She had an extreme allergy to milk and nuts, and she died in Raglan Road, which is an Irish pub in Disney Springs. And it was actually a fucked up case. Like they asked twice whether or not there were any allergy problems. And they said, yep, it's safe. And she's like, are you sure? And they're like, yep, we're safe. And she ate it and she died. And then Disney turned around and said, we found out that your dead wife had Disney Plus. So we want to force you through the arbitration clause in Disney Plus to arbitrate, because that clause says any and all claims against Disney, even though it doesn't originate or have anything to do with Disney Plus. We want to try to force you to arbitrate. And they made this motion in court. Motion to compel arbitration and stay the case. And they got so much shit over that, including from my channel, from a lot of other channels, that they were forced to back down. They're forced to back down. So right here, Disney backtracked on that. So it agreed. So it's saying, hey, we're not doing that. Why? Because they had a wave of bad publicity, right? Now, I do want to listen to this because a lot of you guys, and this applies for a lot of other cases, not just Disney, but a lot of you guys have hit me up talking about arbitration clauses and how arbitration clauses are going in all TOS now. They're going in all the terms of service. They're going everywhere. So this is a very short little clip. where a professor who specializes in this, Dave Horton, speaks about this. I've actually heard of this professor before, so I want to listen to a little bit of this, just talking about arbitrations. We'll at least listen to enough of it to talk about why arbitration is not going anywhere. Everybody adding arbitration to all these provisions is not going anywhere. So we'll listen up to that here, and I'll make my comments. I'll make it a little smaller. I can do it like this.
You might be signing away your day in court. Stay tuned.
I like these like background jams.
Hello, you're listening to On the Merits, a news podcast from Bloomberg.
By the way, Platonic Guardian says Gina has no case. Non-practicing Minnesota lawyer. Yep, that was what they said, and he wasn't the only one. To be fair, it wasn't just Nikki the Real King Rackets. It was also a lot of other lawyers who said that as well, and a lot of other non-legal commentators.
Law and Bloomberg Government. I'm your host, David Schultz. So whenever a legal news story makes headlines in the mainstream press, we here at Bloomberg Law pay attention. And a recent example of this was a very sad story that
Bloomberg loves to toot its own horn, but they're nothing special.
Originated from the happiest place on earth, Disney World. The widower of a woman who died at the park after suffering a severe allergic reaction sued Disney in a wrongful death suit. However, Disney responded that when he had earlier signed up for a free trial of the streaming service Disney Plus, he had, unbeknownst to him, agreed to arbitrate any and all disputes with the company out of court. The story generated a ton of bad press for Disney, and as a result, it later agreed to waive its right to arbitration and allowed the widower's claim to go to court. But it also put a spotlight on an increasingly common practice known as infinite arbitration, where contracts stipulate that all claims against a company, not just relating to the contract, but any claims, must be arbitrated.
So that's what Disney had. Disney had an infinite arbitration. Any claim, not just related to that contract, anything needs to be arbitrated.
Today's guest knows a thing or two about infinite arbitration because he's the one who actually coined the term. University of California Davis law professor David Horton wrote an article 5 years ago that defined this practice and pointed out how common it now.
Yeah, I read this article when it dropped.
Is, especially in online terms of service agreements that few, if anyone, actually reads. Horton also argued that these infinite arbitration clauses shouldn't be allowed under federal arbitration statutes, and he'll explain why he thinks that in a bit.
Well, okay. Well, I don't want to wait too long. Actually, let's fast forward here. But I don't agree with it either. Right? I don't agree with it either.
Parties for the clauses that say that the parties agree to arbitrate any dispute, no matter what the source is. So it doesn't have to be rooted in the underlying contractual obligation. It can just be any claim that arises between these parties for the rest of the parties' lives.
Trying to understand this. A traditional arbitration clause, let's say you worked at Coca-Cola or something. It's
very simple. I love like these NPR people. They like the NPR types, right? Because like Britt Cormier said, this is like one of these NPR type news stories. They like pretend to be ignorant, but it actually is a pretty simple concept.
Arbitration would say if something happens to you at work, you slip and fall at work or you get injured, you agree to go to arbitration for that. An infinite arbitration clause would be like if you are at home drinking a can of Coca-Cola and it makes you sick, you also would go to arbitration for that.
That's exactly right. So there's no relationship whatsoever between the wrongdoing that gives rise to the claim and the contract that contains the arbitration clause.
You meant
somebody said it in the chat. I want to give credit for like smart comments to Brain Fried, who said, talk about a screaming definition of unconscionable. Yes, that is a very astute. You obviously have a legal mindset by calling out unconscionable, extraordinarily unconscionable. It shocks the conscience. That's literally what the interpretation of that is. It's so ridiculous that like it's offensive to morality, right? That's what that is.
That this kind of came about 5 or 10 years ago?
That's when it became more prevalent.
How and why did this start? Actually, you didn't use the phrase come about in your article. You used the phrase metastasize, which I think should give listeners a sense of what you think of these arbitration clauses.
As best as I can figure out, what happened was there were companies that did use these ultra broad or limitless arbitration clauses, but it seemed pretty haphazard until the 2010s when the US Supreme Court decided a bunch of cases that effectively held that the mere existence of an arbitration clause is the equivalent of the waiver of the right to bring or participate in a class action. And so they began to push the envelope a little bit by expanding the scope of their arbitration agreements away from claims that simply originate from or are related to the underlying contract and to claims from any source.
Okay, so they wanted to see the court, the Supreme Court was like, all right, you can use an arbitration clause to prevent class actions. Okay, that's one thing, because a class action would be about a related claim. But something that's so divorced that it wouldn't even qualify under a class action because it's something so ridiculous, so extracted, right? That's taking what the Supreme Court said and taking it to the next level.
I see. So it was the Supreme Court kind of opened the door for this a little bit.
I think so. I mean, it's very difficult to find like concrete proof of a catalyst, but I think that's the relationship.
Before we get more into this, let's just sort of level set here and make sure that everyone in the audience understands
I hate that fucking
why
word,
arbitration can be really bad for you if you're a plaintiff or a potential plaintiff.
Yeah, that's a great question. So plaintiffs' lawyers seem to believe pretty firmly that they get much better results for their clients in the court system as opposed to in arbitration. And
that's not an opinion. That's true. That's factually true. There's been empirical studies that prove that.
There's one way in which I think no one can deny that that's true, which is just class action rights. You simply have class action rights in the court system and don't have them within arbitration.
Sure.
When it comes to individual cases, it's a little bit more fraught because it's very hard to sort of empirically demonstrate that the same case would be decided differently in different forums. But plaintiffs' lawyers are convinced that because the procedural and evidentiary rules are different in arbitration, and because arbitrators, unlike judges, are paid by the hour, for those reasons, plaintiffs' lawyers just feel like they have an uphill climb in arbitration.
Well, let's get into the main reason why I called you up and wanted to talk to you is because particularly the Disney case that made a lot of headlines and got a lot of people outside of the legal world talking about arbitration. Were you surprised?
Because Disney was so fucked up as to do that and still pretend, oh, we care about people. We're on the right side of history. And yet they're literally trying to force someone into a kangaroo court over a wrongful death case. Are you fucking kidding me?
When you saw that story and, did you feel a little vindicated that you were saying, hey, I wrote this article sort of 5 or so years ago that essentially called this exact scenario?
That's a nice way of looking at it.
Yeah, right. I mean, certainly it wasn't a happy story for the people involved, but It made your article seem very prescient.
Yeah, well, thank you. Right. So, I mean, I guess I was not surprised. There have been other cases that I think have been almost as potentially sort of resonant that just didn't, for whatever reason, catch the public's imagination. So in some ways, it seemed just like a continuation of something I had been tracking for a little while. A lot of people can relate to this idea that they do something almost mindless, like, signing up for a Disney Plus free trial, and somehow make, this tremendous sacrifice of their legal rights where they're...
Well, and that's a problem with TOS. Most people don't read TOS. So you have no fucking idea what you're signing up for, right? So people might sign up for something and not realize, oh yeah, this is giving, for example, permission for AI to scrape your data, right? Or whatever else, right? Because nobody reads the TOS, right? That's what the joke for that South Park episode with Apple, right? It doesn't read, right? Because it's not reading the terms of service.
Giving up the right to sue Disney for any purposes. And the fact that it would later come out in this horrible wrongful death claim that has just no logical relation to Disney Plus streaming. I mean, I think those are the reasons why it became a big media story. But as I said, this is the type of thing that has been happening with greater frequency over the last 5 or so years.
Yeah, you're right. And I guess I'm realizing this kind of gets at two parallel trends. One, infinite arbitration and the broadening of arbitration clauses. But two, are these terms of service contracts.
And someone in the chat said, didn't courts say TOS are not binding? No, what I said, and I've said this on my channel, TOS routinely get thrown out when they're brought to court. But the problem is you need to have a shit ton of money to fight Disney. We just saw that with the Gina case. You need to have a ton of money to fight these TOS. And most people don't have the money, right? So when we talk about Twitch or YouTube or whatever other TOS that people don't like. End of the day, people don't have the money to go out and fight the TOS and get them invalidated. It's not worth it. It's better just walk away.
That everyone signs and no one reads, that are proliferating as well. I mean, that's a whole other topic that led to this scenario coming up.
Yeah, that's exactly right. And it's funny.
And what will happen is they all have clauses in them. They all have what's called a severability clause, which means if one section is ruled illegal, the rest is still in effect. And that's also in a lot of contracts. You're going to see a contract called a phrase called severability. That means that every single provision is severable, meaning you can take it out and delete it, but the rest is still okay, is still binding. So even if one section of the TOS, let's say it's the arbitration clause gets thrown out, the rest is still effective, right? That's the way those things work.
So I feel like it's sort of enjoying a kind of a renaissance as an issue that people are concerned about, in part because we consent in all these ways now that are just so attenuated from any kind of subjective understanding. Signing up for a streaming service is the perfect example. You press a button on your phone or remote control, and that's it. You've just signed this enormous contract that you probably never even saw.
Okay, so let's get into some of those examples that you talked about. You mentioned that the Disney case is far from the only situation where it seemed like there was an egregious use of this infinite arbitration. You cited several examples in your article. I wanted to see if you could summarize a few of them and tell me about how this kind of thing is far from uncommon.
In my mind, I think the sort of most similar case to the Disney case involves Airbnb. So if you are thinking about going on vacation, maybe you want to compare hotels to like Airbnbs, you go to Airbnb and you have to register for an account. So when you register for an account, you agree to one of these infinite arbitration clauses. And there have now been 2 cases decided in state courts in which somebody has gone to Airbnb. And I don't believe in either case they actually rented a property. All they did was just sign up for the service. Then down the line, months or years later, they happened to be at somebody else's Airbnb when they were horribly injured or killed. And so there were lawsuits either filed by the person injured or, in the case of the person who died, their estate against Airbnb for various reasons. And Airbnb argued that these claims had to be arbitrated. And just to reiterate, it was a total coincidence that these injuries happened to occur.
That's pretty similar. Like, that's a pretty fucking similar situation. Did you guys know about that? How many of you know? Did you guys know about the Airbnb situation? I'll put that in there. So did you know about the Airbnb arbitration clause? I want to know if you guys knew about that. That one's pretty big. Now, I knew about this, but it's still shocking to hear. Even hearing it again is shocking to me.
On someone else's Airbnb rental. It had nothing to do with the account that the plaintiff had opened.
There was another case that you cited in your article involving a cruise.
And once again, remember, it's not even their Airbnb. It's totally somebody else's. And think about how many houses are Airbnbs. That is crazy. That's like going to somebody's house and you sign an arbitration clause with like the plumbing company or like the, whatever, some other service company, right? Let's say it's like a lawn company and you trip and fall on the lawn and you're arbitrated out, but it's somebody else's lawn, right? It's crazy. It's nuts.
Cruise ship and an employee at a cruise line who was sexually assaulted and then tried to sue her employer and wound up in arbitration.
Cruise lines are famous for this. All cruise lines and airlines use arbitration clauses, all of them.
Get into that a little bit. That struck me as a way that infinite arbitration really affects employment law.
So in this case, there was a woman who was employed on a cruise line and she worked in the spa. And later, she alleged that a coworker had raped and impregnated her. So really horrible allegations.
So I'm pretty sure when you sign up for arbitration, you're not like, hey, this includes grape and impregnation, right? Like, I'm pretty sure you don't think that's going to be arbitrated.
And she had agreed to arbitrate with her employer, but she argued that the assault had taken place when she was off duty and in a residential area of the ship. So essentially, she was arguing that, I wasn't at work. I was, on this cruise line, but I wasn't on my job. And the judge that decided that case held that that argument was irrelevant because the text of the arbitration clause said that it just applied across the board to any claim. It didn't actually require any kind of a nexus between the claim itself and the contract that contained the arbitration clause.
And also, again, I mean, that's a contract that you sign when you get hired. It's not like, when you get a job, the first thing you do is like read over the whole contract and then negotiate with your, now employer. You don't have a lot of negotiating leverage when you start a job.
That's absolutely right. And I think a lot of people feel that employment arbitration clauses can be especially coercive. But with employment, no one's going to walk away from a job just because of some fine print they don't like.
Tell me about the role that the court system plays, and particularly getting back to the Supreme Court, because I got the sense reading your article that there have been some lower court judges who've seen these clauses come before them and say, hey, this looks pretty overly broad.
Yeah, no shit. I mean, almost any judge would. That's why I said most judges don't like them, right? And that's why I don't, these NPR types, they always like hold back, no. Judges don't like this bullshit. They don't like it. It's clearly wrong. Like, to anybody with a sense of morality, there's no maybe. No, it's wrong. Period.
But every time an arbitration issue has gotten to the Supreme Court in the last, as you mentioned, 10 or 15 years, the Supreme Court has always consistently decided that arbitration clauses must be upheld as written. There is no, room for interpretation here.
This is actually something that I think has the potential to be a little bit more interesting than your traditional consumer or employment case that gets up to the Supreme Court. As you mentioned, the Supreme Court has a reputation for issuing a series of pro-arbitration rulings that favor big businesses. There is this massive, lurking, unresolved tension between an infinite arbitration clause and the text of the Federal Arbitration Act. The Federal Arbitration Act has a centerpiece, Section 2, which is the clause that makes pre-dispute arbitration agreements specifically enforceable as a matter of federal law. So it is just the absolute nucleus of the statute. That provision says that it only applies to claims that arise out of the contract that contains the arbitration clause. So on its face, the Federal Arbitration Act doesn't seem to apply to these infinite arbitration clauses.
So it sounds like that issue has never gotten before the Supreme Court, though.
That's 100% correct. And there was one case a couple years ago where there was a footnote, it's Viking River versus Morea. There's a footnote where the court acknowledges that Section 2 of the FAA has this limit. And the court, doesn't really consider whether the limit is something it's going to take seriously or not. But there's reason to believe the court might actually take the text seriously. The court is filled with textualists. Even the conservative justices are.
This is clearly a California judge. He's clearly shitting on a little bit, hinting at the conservatism in the court. But generally, what the court, and to translate this, because he's putting a little bit of a Californian spin on this, to translate into this in a little bit less biased version, right? A lot of the justices, right, if you believe in more of a free market, right, you believe in freedom of contract, the ability to enter into contracts between two parties. The problem is that nowadays, in many circumstances, the parties aren't at parity, right? And yes, you're free to enter into whatever contract you have. You cannot sign a contract if you don't like it, right? But there's more and more of these boilerplate contracts that have these terms in them, and they're so long, or TOS, have they're so long that you can't reasonably read them or access them, especially in the time allotted to do the thing, right? And time allotted to go and proceed and do the service that you want to engage in, right? So you're going in your, let's say going to a theme park, right? You're not going to read all of Disney's terms of service, right? They're multiple pages long, right? So yeah. It's definitely a little bit of a California spin there, but the point that it gets to, and I guess I'll stop it there. But the point what he's getting at is they may actually turn to the arbitration rules themselves, which say, hey, these sort of clauses are not favorable. So there's multiple reasons to get rid of them. But the moral of the story is Disney did back down. That doesn't mean we won't see this again. So expect more crazy arbitration stuff. And if you see me next time covering a crazy arbitration case, you know why, because of stuff like this, because of the infinite arbitration hack, right? So you guys now know. Who said this? Linmar said, since a person died due to gross negligence, shouldn't the case be prosecuted by the state prosecutor, not the family lawyer? No, it's not a criminal case yet. Yet. Maybe if there's more information, it might be, but it's not criminal yet, right? So at this point, it's not criminal, it's civil. So only if it goes criminal, then it would be a state prosecutor in that side. But good catch there. Good catch there. Even if you sign up to work in a nuclear power plant, they don't forget your health and safety. It's so true. It's so true. Let's see. Oh, Alfire Ava said, this is a California judge, big time California sping. I passed my bar exam in California, stopped practicing after a couple of years. Yeah, it's real bad in Cali. I knew a girl who wanted to be a California lawyer, and she ended up also becoming an expat, but she works in like Switzerland now because she wanted nothing to do. She's doing federal tax law because she wanted nothing to do with California law, nothing to do with it whatsoever. Right? I think she works for like Credit Suisse or something, and she's over in Switzerland. Yeah, some harrowing things you end up discovering in normal divorces. Yeah, it's crazy. But if something criminal comes up, they'll charge Disney or whoever did it with that charge. I have one last Disney L to talk about today, and this is a big one. We just got news that Universal Studios is opening its 4th Disney park 6 months early. We thought they were going to open up Epic Universe later next year. Nope, in time for Memorial Day. It will open to visitors on May 22nd of 2025. This is going to put Disney so behind the game. They're not ready for this. Their next park, Disney cannot spin up a new park in a year. It's not possible physically. I mean, you can't even get the approvals. It's not possible at all. It's going to take them 5 to 10 minimum to get a new park, which is what they've already made a promise to do. But they're going to be way behind with Epic Universe opening, which is going to be a massive area, including at least Harry Potter, Super Nintendo, How to Train Your Dragon, Monsters. There's going to be a whole bunch of stuff there. And that's just the beginning, because there's going to be expansions to this park. So, there may be Pokemon coming in, other stuff coming in. So just wait for all that other stuff. There's also going to be a brand new hotel, the Helios Grand Hotel, and 10 other hotels at the new, joining 10 other hotels at the resort. So tons of stuff opening up. It's going to be massive. The area, the footprint of this park is massive. So it's going to absolutely be amazing. Now, I really look forward to that. But this is yet again another Disney L. So we've gotten 3 Disney L's today. We got the Gina Carano case, arbitration, and the theme park. So that actually, in a way, catches me up. It's been a while since I have done Disney, but it feels good to be back and cover these topics, right? By the way, most of you did not know about the Airbnb arbitration clause. But if you guys enjoyed this, if you enjoyed this type of coverage of Disney, please make sure to smash a like button. We had 1,524 people, so I guess you guys liked it, right? But we're only at 800 likes, so maybe if we got to 1,000, I'm super convinced. But if you guys enjoy this type of coverage, let me know. I know some of you are here no matter what I cover. Some of you are here for Disney. Some of you are here for other topics. But just glad to bring this type of coverage to you, and glad to stick with this case until it terminates. But until next time, guys, I'm going to take a little break, and I'll be back tomorrow for the Sarah Boone case, which starts at 8 p.m. my time, which may be like 9 a.m. EST, something like that. So I'll be back with that one. Maybe with a guest or not. We'll see. But until then, guys, take care. And until then, Disney will just be.
You are coping and seething. You just can't accept what you're seeing. Yet you're coping and seething.